Hello and welcome to this webinar from Jurassic HR on the subject of HR for non-HR managers. During today's webinar, we're going to be looking at three key elements. We're going to do some introductions, we're going to look at what exactly is HR, and then we're going to break down some of the key elements that would impact you in your roles. So firstly, let's tell you a little bit more about me. I'm a chartered member of the CIPD. Now, I've been involved in the HR industry for over 15 years now, and I am the founder and the owner of the Jurassic HR Training consultancy company. I also host the HR Show, available on all major podcast platforms, including Spotify, Amazon, Apple, and Google. My contact details are at the bottom of this screen. You can email me, andy@jurassichr.com. You can tweet me at JurassicHR, or you can visit the website, which is JurassicHR.com. So let's kick off by asking the question, what exactly is HR? Well, HR is the strategic approach to the effective management of people within a company or an organization. Now, that can be that they help the business gain a competitive advantage. The overall purpose of HR is to ensure that the organization is able to achieve its success through its people. And that comes down to key elements such as recruitment, such as policies and processes, such as maintaining employment law. So let's look at some of the key elements that you will be doing in your role as managers. Discrimination. Now, this is one of the key areas that we focus on within HR. Discrimination means treating a person unfairly because of who they are or because they possess certain characteristics. Now, if you've been treated differently from other people only because of who you are or because you possess a certain characteristic, then you actually may have been discriminated against. And discrimination comes in 4 different styles. Now, under the Equalities Act, the 4 types that they mention within the workplace are direct discrimination, indirect, harassment, and victimization. Direct discrimination occurs when a person is treated less favorably due to a protected characteristic which they possess. This is ordinarily direct discrimination, and it's the only type of direct which may be lawful, but only if it's classed as objectively justifiable. A protected characteristic possessed by someone who they are associated with, this is known as direct discrimination by association. A protected characteristic for which they are thought to possess, and this is known as direct discrimination by possession. Now, although there is normally a deliberate type of act or exclusion, direct discrimination does not have to be intentional. This means that even if direct occurred unintentionally, a claim could still be pursued. Indirect discrimination, however, is usually less obvious than that of direct, and it's actually normally unintended. Generally speaking, it occurs when a rule or plan is put into place which applies to everyone and is not in itself discriminatory, but it can affect individuals with a certain characteristic as a disadvantage. Harassment is unwanted conduct related to a protected characteristic, such as gossip, intrusive, or inappropriate questioning. And victimization occurs when an employee suffers a detriment because they have done something in good faith, such as whistleblowing or raising a grievance. Now, direct and indirect discrimination can also be present when you're recruiting. And recruitment can actually be a massive minefield because there are so many things to consider when you are going through a recruitment process. Everything from the style of the advert, to the wording, to the requirements that you're looking for, to the individual that you take on, and even how you interview. So within the recruitment, there are some very basic categories that we're going to discuss, and one of them is called advertising the role. Now, did you know that there is no legal requirement to advertise a job? However, it is best practice to do so. If you use social media to advertise, be careful not to limit who can see it to certain characteristics or ages. You should choose the wording carefully and appropriately as to not discriminate against someone's sex, i.e. using the words waitress or barman. When you're choosing which applicant to interview, avoid checking social media platforms, as this could lead to discrimination. For example, and there have been cases where employers have seen that an applicant has got a disabled child and they then don't bring them to interview. Create a scoring matrix to assess each applicant with a score out of 5. Now what this means is that each person has the same questions, the same interview process. Makes it fair, makes it just. There ideally should be 2 or more people involved in the process to avoid claims of discrimination. And by law, you must ask anyone attending an interview if they need any reasonable adjustments so they can be made and they can be done for when they attend. When you move on to the interview itself, it's best practice to prepare a list of questions to ask during the interview, as well as advise to ask all applicants the same questions. However, this is not a legal requirement. But if you're following the scoring matrix, your core questions will be the same for all. What the interview allows you to do is ask the core questions and then spin off if the candidate says something which you want to pick up on later. So you're not confined purely to those core questions, but use them as the base and the model. So when you've done the interview, when you've found the candidate that you want, you're about to do the job offer. Now the job offer should include some core pieces of information. And that's of course the job title. What are you hiring them to do? It should be a confirmation that you've offered them the role. Any conditional conditions to the offer, the terms of the employment, such as the salary, hours, the location, the entitlement for holiday, and any benefits such as pensions. It should have the start date and the length of time of any probation periods. So if you run a 3 or 6 month probation period, that needs to be mentioned within this document. It should have the contact details for someone within the organization. Now, normally this would be your HR team, but if you're a small business or you're running HR yourself, then that could be you, it could be your assistant, it could be anyone in the business who acts as a point of contact. And it should also have clear guidelines of what they should do to either accept or decline the offer. If you do not include any conditions within your job offer, it's known as an unconditional offer, which means that if you withdraw, you could, in effect, be breaking the law. Now, the employment contract is a legal document between an employer and an employee. It begins from when the employee starts work, even if no contract is in place. By law, you must provide anyone who is classed as an employee with a written document if they are employed for more than 1 month. By law, an employer should provide any written documents within 2 months of the start date of the employee. And then you've got salary, and salary is about ensuring that you're fair, you're consistent in your structure. It's making sure that you're aware of the minimum wage requirements, that you don't fall under the minimum wage requirements, but also that you are paying people equally and justifiably. Holiday and absence management. Holiday. I'm sure we would all love a holiday at the moment following what we've been going on since March of 20. But holidays and absence management are key for any manager. So all employees are entitled to a paid holiday regardless of whether they work full-time, part-time, or on 0 hours contract. An employee starts to accrue holiday from their first day of employment. It continues during sick leave, maternity, paternity, or adoption leave. For a full-time employee who works 5 or more days a week, they're entitled to 28 days of leave, paid leave per year. Part-time employees must receive the same amount of holiday as full-time, which is then pro rata based on the number of hours or days they work. And holiday pay should be at the same rate as an employee's normal pay. If the employee does not have fixed hours, their holiday pay should be worked out as an average from the previous 12 weeks. If an employee is owed less than a full day's holiday entitlement, you can allow the employee to start later or leave work earlier. An employer can schedule when an employee needs to take their holidays, such as on bank holidays or over Christmas. The notice of leave should be twice as long as the period of leave being taken, and employers can refuse or cancel a holiday request. This should be provided with the same amount of notice as the length of the request. Employees must take their legal minimum holiday entitlement during the holiday year. When the year starts and ends is up to the company, but this should be documented within the employment contract terms. Contracts of employment should also state if they can carry over any holiday and what restrictions there are in doing so. If an employee has been on long-term sick leave, they are entitled to carry over 4 weeks paid holiday, which must be used within 18 months of the date of which it carried over from. If an employee decides to leave your company, you can request that they use any holiday entitlement during any notice period. If there is any statutory holiday entitlement left, then you must pay the employee for this time. This is called payment in lieu. However, if the employee has taken more holiday than their entitlement by the time their notice period would end, you as an employer can deduct this from any final pay. Employees can request unpaid leave at any time, but it is up to the employer as to whether this is accepted or not. So moving on to absence management. Now this concerns sickness, illness, and long-term absences. Now, illnesses lasting less than 7 days can be self-certified by the employee. If their absence lasts for 7 days or more, then you ask them to provide a fit note from their GP. If the employee cannot provide a fit note, this could need further investigation and then become a conduct issue. Unfortunately, within employment, we have occasions where our employees and our team members move on to long-term absence. But what do you do if this happens? Well, the key thing is to keep in regular contact with the employee about their position. Be clear about their sick pay, explain any updates, and think about whether you need to contact their GP to ask when or if a return to work will actually be possible. Will there be a full recovery, and is a return to the same work doable? Should they have a phased return, either through reduced hours or flexi time? And if any reasonable adjustments must be made so that they can return to work. If in circumstances where the evidence points to the fact that they cannot return back, then you can go under what's called an ill health capability process. And we can explain more about this if you wish. Please contact me directly. When an employee returns back to work from either a standard period of sickness absence or long-term sickness absence, you really should conduct what's called a return to work interview. Now, these should be used to welcome the employee back into the business. They should be used to check that they are well enough to resume their duties and also update them on any changes that may have happened. If they have a fit note that states that they may be fit for some work, you really should discuss what duties they can do until they are fully recovered. Now, this could mean that they are on amended restrictions for a while. It also provides an opportunity to see if the absence was due to an underlying condition. Where the absence record requires improvement, this must be explained to them with the company's expectations and also any consequences if they aren't achieved. If the return to work interviews are failing to result in improvement, agree trigger points with your employees, making it clear repeated absence will automatically lead to formal action. But please be sensitive about the reasons for repeated absences or underlying conditions. However unexplained or unjustified absences may be, treated as conduct issues leading to disciplinary action and ultimately dismissal. Sometimes we don't know why our employees are off or what's happening at home or in their personal lives, and that can sometimes play an impact in what they do. So make sure you have a chat with them, and these return to works are an ideal time to begin to identify issues that may be occurring and begin to identify issues that we could help as employers help to resolve. Discipline and grievance, two of the most common processes that I think any manager will go through within their working life. But they are different. A grievance is a formal complaint that is raised by an employee towards an employer within the workplace. This may be regarding another employee, or it could be regarding the organization itself. Issues should be taken seriously with a record of what the issue was, the process that you followed, the details of any conversations, the solutions or next step, and the reasons for those solutions or steps. Your grievance process should, as a minimum, follow the ACAS code and set out that the organisation would deal with all grievances in both a fair and consistent way. And also that all grievances will be investigated, with all parties allowed to contribute to the process before any decisions are made. Formal grievances raised by employees should have a meeting within 5 days to follow these steps. Allow any employees enough time to prepare fully before any meeting. Arrange for someone to act as a note taker and a witness. And allow the employee who raised the grievance to explain their concerns and show any additional evidence they may have. For grievances relating to legal or contractual issues, they have a legal right to be accompanied by either a colleague or a trade union representative. And any notes that have been taken should be made available to the employee, and a timescale should be documented for when a decision will be made. So what's a disciplinary? Now, an employer could start formal disciplinary action against an employee if they have concerns about their work, conduct or absence. So unlike a grievance where it's the employee bringing a complaint to the employer, this is the employer taking action against the employee. And it really could be anything. I've done cases of disciplinaries in my career of ill health, of failure to work to a reasonable standard, to failure to follow a management request, to timekeeping. For capability or for performance issues, the organisation should have a documented process for dealing with underperforming employees. Now that process also needs to be shared with the employees ahead of time. Employees need to know what processes and policies you have in place, otherwise they can't be held accountable for them. These processes need to take into account any support and training to help the employee improve. Misconduct or inappropriate behavior concerns an employee breaking workplace rules. Examples of this can be detailed within employment contracts or most likely within the employee handbooks. An employee can be held accountable for their behaviour outside of the workplace if it affects the organisation and the organisation's reputation. Employers, however, should carry out a thorough investigation to gather evidence. If an employee wants to resign during the disciplinary process, this could lead to a claim of constructive dismissal at a later date. The employer should encourage the employee to complete the disciplinary process first. If the investigation shows there is a case to answer, the employer should invite the employee to a hearing in writing and in good time before the hearing include the alleged misconduct or the capability issue, all evidence from the investigation or information that will be discussed at the hearing, the date, time and location, the employee's right to be accompanied, and then also the possible outcome from the hearing. Within HR, that last statement has always filled us with a piece of dread. The predicted outcome, the potential outcome. Some employees will go into a hearing going, "You've already made your decision." We haven't. What we're doing is letting the employees know that this could be the result. This could be what you come out with. But until that hearing is completed, there have been no decisions made. So when you reach the hearing, the employer or the hearing manager should set out the misconduct or capability issues and go through the evidence. A note taker should be assigned to ensure that all information is recorded. Now, normally this would be a member of your HR team. If you're in a position where you don't have a HR member, then I would suggest you bring another independent manager in to act in that capacity. The employee should be given the opportunity to answer any allegations, present any of their own evidence, or to ask questions of the employer. Now, I stress here, present any of their own evidence. This is very, very unusual if this happens. Any evidence should really be presented at the investigation stage. And at hearing, if an employee turns around and says, "I have X, Y, and Z," as a hearing manager, you are entitled to suspend and adjourn the hearing to go away and to assimilate that new evidence that you've been provided and then reconvene. You do not have to continue if new evidence has been provided at that time. And your questioning should then also be, why has this only just been presented now? When you come to the outcome, we bring the individuals back into the business. We ask them to come back in. We ask them to discuss the reasoning, and we set out what the actual answer is all about. And they can be various levels of severity. So an informal or a verbal warning is applied when the issue is deemed as a minor one. Records should be kept which detail the nature of the warning and any timescales which apply to it. Written warnings are usually formal warnings, and that's usually the first stage within an organization's disciplinary process. An employer can issue a final written warning if within a set time frame the employee has repeated or committed a misconduct or not improved their performance. In serious cases, an employer can issue a final written warning without issuing any previous warnings. And in other situations, called gross misconduct, it can be instant dismissal. If an employee is dismissed, whether because they've reached that stage within the disciplinary process or because of a gross misconduct, they should be informed in writing as soon as possible the reason for the dismissal, the date their employment will end, and their right to appeal. An employee can appeal against the decision if they feel it's too severe or unfair. The minimum period of notice to be given will be set out within your employment contract, your handbook, or your policies. An employee can be paid in lieu of any notice, but this must also be specified within those documents. In the case of gross misconduct, an employer can dismiss the employee without any notice at all. So that's our whistle-stop tour on some of the key areas of HR for non-HR managers. But how can Jurassic HR help you and your businesses? We offer a full HR consultancy service with an initial free 30-minute consultation. And in that consultation, I will sit down with you and take you through a health check. And that health check will be asking, what is going well for you and what's not? Where do you see yourself going and what can we do to help you? Once we've had that consultation, we'll go away and create a fully bespoke service package for you. This could be a project, could be a change, could be reviewing of your documentation, could be your learning and development functions, it could be pay as you go, or it could be retained services. The report that I send to you will clearly detail my recommendations and how we can work together to ensure that your queries that you have are turned into practical solutions. Now, I do have a webinar offer for this session, and that involves my Jurassic HR training. If you have found the information contained in this presentation, albeit at high level, interesting and informative, then we can create bespoke line manager training courses. These are designed for your business based on your values and your policies. They will include the latest in employment law, they will include the latest processes, and the latest techniques in order to get the best out of your managers for these type of situations. They can be facilitated online or, when finally permitted, in person at your business locations. And if you'd like more information on that, please contact me via the website or via the email. A little bit extra, the official podcast that we do, the HR show, is available on a weekly basis from all good podcast providers. You can subscribe today at Apple Podcasts or Spotify, Amazon, Stitcher, wherever. Search for the HR show and this logo will appear. The HR show contains information and interviews from HR professionals, from business leaders, from all walks of life, and coming up soon will be a special episode based on the education crisis in respect of GCSE and A-level examinations being cancelled due to the coronavirus pandemic. And I encourage you all to subscribe, have a listen, and please leave me a review. And that's it for this webinar today. My contact details are on screen. Please email me, andy@jurassichr.com, or visit my LinkedIn. If you'd like to follow me, that's absolutely fine. I would welcome your connection. Call me on 07873 874478. And again, visit the website, jurassichr.com. If you visit the website, there is a consultancy booking tab. If you click on that, and all of my available dates will be available for the next 60 days. And I look forward to speaking to you on your consultation. I look forward to working with you. And if I don't, then thank you so much for your time today. It's been a pleasure to speak to you. And I hope you found the information informative. And for now, I wish you all the best. Take care.